Tonight, I'm sure you've all heard, but just to recap really quick, the party is actually going to be in this room at 9 o'clock. All the beer is free until midnight, and then there's cash only from midnight until 1, and it shuts down at 1. The entrance is going to be through the back door from the terrace level, and you also get a ticket when you come in for a free mixed drink. Also, our Lost and Found is growing. Oh, one more thing about the party. You actually need your badge at all times. And if you want to stay in the party, you'll have to remain wearing your badge. And about Lost and Found, our Lost and Found is growing. So if you've lost any items, please head over to registration and retrieve those items. Now I'd like to go ahead and introduce our next talk. We got some gentlemen from the EFF here to answer your questions, and it's going to be an open forum where what we'll have you do is we'll just hand you a mic if you want to come up here and ask your question on mic, and then they'll go ahead and answer your questions. And to do that, we have Kurt Opsahl and Nate Cardozo. All right, take it up. Can we get the mics turned on? Maybe? Nope. Where's Bob?
All right, one moment, please.
We can also, if you want to get started with this mic up here, we could do that.
All right, well, while we're working on that technical difficulties, I'll come to the working mic. Oh, that does sound much louder. So hello, everybody. My name is Kurt Opsahl. I'm the Deputy General Counsel of the Electronic Frontier Foundation. I'm here with my colleague, Nate Cardozo. Together we work on, amongst other things, the Coders' Rights Project at EFF, which is well, let me start out and say, how many of you are familiar with the Electronic Frontier Foundation? All right, so I can keep the description pretty brief. I think you guys know about generally what we do. We try and fight for your rights online, and one of the ways in which we do that is the Coders' Rights Project, which is where we try to provide help to security researchers, people who have discovered a vulnerability and want to discuss about it, or concerned about the legal implications of either their research or the disclosure of the vulnerability. And so we love to talk to those people and answer questions, but this is not the forum for doing that. So if you have something that you want to confidentially talk to us about, you can seek us out after or send an email to info@eff.org, and we'll try and set up a time to talk. But in that this is a public forum, this is where you can ask all sorts of questions, but try not to ask the ones that are about your particular legal situation where it should be done confidentially. So with that, we're going to hit a couple of issues. So as I said, we're lawyers and we do some aspects of the work, but EFF actually has many different people working to help you out. We have, in addition to the lawyers, there are technologists who do software projects. We have activists who try and push for political change through petitions, through contacting legislatures. So we're going to touch on a couple of those projects, and we can do our best to answer questions about them. But mostly we're on the legal side of the fence. So I guess with that brief introduction, we'll start to talk about some of the legislative issues that could be of interest. And so, Nate, you want to start with ECPA?
Sure. So one of the things that is in my bailiwick at EFF is proposals in Congress right now to reform the Electronic Communications Privacy Act, which we call ECPA because lawyers love acronyms. ECPA was passed in 1986 when Gmail was not even a glimmer in Larry and Sergey's eye. Webmail didn't exist. It was a strict client-server model back then, essentially, with exceptions. And so ECPA doesn't get the way that people use email. And right now the law makes a distinction between opened email and unopened email, makes a distinction between email older than 180 days, because hypothetically, back in the day, if there was email still left on the server after 180 days, that meant it was abandoned. Now, of course, those distinctions don't make any sense whatsoever. So we're working with Senator Leahy primarily, as well as Representative Polis, to update the Electronic Communications Privacy Act to make sure that law enforcement always gets a warrant before it can open your email. The major opponent in this fight, surprisingly, is not the Department of Justice, it's the Securities and Exchange Commission, which was surprising to me and was surprising to most of my colleagues. So ECPA reform is going to be a big push of ours in the 114th Congress. I didn't go to law school to do legislative work, and I never thought I would do it, but I kind of like it, and you know, we might win on this one. Fingers crossed.
And there's another, well, it's not quite a bill yet, but another legislative issue that I think you guys should know about. As some of you may have seen, earlier this week, a couple days ago, the Obama administration came forward with their recommended amendments to the Computer Fraud and Abuse Act. That is the primary federal anti-hacking statute. This was part of a broader cybersecurity bill. And they sent it along to Congress saying, could you please put out a bill that accomplished these things? They sent it with a cover note saying that the Sony hack showed why this was necessary, though oddly enough, nothing in their amendments would have changed anything with respect to the Sony hack. But it was in the news, and they feel like they have an opportunity. The proposal itself is extraordinarily similar to one that they made in 2011. And that was not the first time either. So these are some aspects of the Department of Justice's wish list that they felt like now would be a good opportunity to push forward on. And this wish list has a number of disturbing things. It is taking a bill which is actually kind of problematic as it is, and in many ways making it worse. And I'm going to highlight a couple of the features of the proposal that we're going to be opposed to. One aspect of it is they talk about unauthorized access and then exceeding your authorization. And the current language just says, exceeds authorization. There's been some question about what that means. The Department of Justice has taken the position in some litigation that if you violate the terms of use of a site, you are exceeding your authorization because you're no longer authorized to use the site. They've brought some cases along that line saying that is hacking. This leads to some ludicrous circumstances. For a while, we were looking at some various terms of service. We saw that 17 magazine had a provision in their terms of service saying that you had to be 18 or older to use their website, so that anybody who was 17, who went to 17 magazine, would be in the DOJ's argument, if it were adopted, committing a hacking crime. And this is, somewhat ludicrous. But there was some good news that some courts had interpreted the exceeds authorization to exclude terms of service, to say that it had to be a technical protection and less of a terms of service thing. So the DOJ didn't like that so much, and they have proposed in the new bill, and let me actually just get the language, that exceeds authorized access. Now, 1 second. Basically that the exceeds authorized access is if you should have known, had reason to know that it was a bad thing. For the purpose that the accessor knows is not authorized by the computer owner. And so this is somewhat broader even than the terms of service, because it also is an attempt by the DOJ to encompass circumstances in which, even though there is no written prohibition against doing it, they feel like they can convince a jury that you should have known not to do that. And what we'd like to see instead on this is that it be technical protection measures, that if you ask a computer server for something and it tells you no, then that's a technical protection. But if you ask and that provides you the information, then that is the act of authorizing it. So if you go to a website, type in a URL, and it comes back with a response, there'd be no way to say that that was unauthorized. This is a reference to a case which they brought against Andrew Auernheimer, who had iterated some numbers in a URL, and they believed that that was a form of hacking and prosecuted him for it. Another concerning feature about the new CFAA proposal is they have a provision right now that is about sharing passwords. And if you share a password with an intent to defraud, then that is a violation of it, and it starts out with a misdemeanor, and then on your first offense, and if you do it, subsequently, it can rise to a felony. And so what they want to change that to is they're removing the intent to defraud, changing it to a 10-year felony, and adding, in addition to passwords, this term, undefined term called means of access. So that if you are distributing a means of access, this is a potential 10-year felony. And then they limit it a little bit with some language which is not very comforting. And I'll get that exact language as well. And unless you have sort of knowing or having reason to know that a protected computer would be accessed or damaged. And so this has raised a lot of people's concerns that it broadly defined, if a court or the DOJ decided to look at means of access in a very broad sense, they could say that proofs of concept, pen testing tools, exploits would all be a form of means of access. And if you were putting it out in an environment where there might be somebody who would misuse it, you don't want to be having to defend a case on whether you did or didn't have a reason to know that some bad person was in the audience. Now, I mean, the DOJ will tell you that through prosecutorial discretion that they would not do that, but we have not seen enough to give us confidence that they would. So anyway, that is just a few of the things with CFAA. It is a big problem. We'll be fighting against it.
And one sort of soundbite you can take home from that is, under the administration's new proposal, sharing your HBO Go password with your friend is now a 10-year felony. We think that's ridiculous. One of the cases that I'm working on is a FOIA lawsuit, a Freedom of Information Act lawsuit that EFF filed. We sent a Freedom of Information Act request to both the NSA and the Office of the Director of National Intelligence, the ODNI, seeking information about the so-called vulnerabilities equities process. This is the Obama administration's new term for when they sit on ODAs. They say that they sometimes do, and that they have this process to decide whether and when to do it. And they've called it the vulnerabilities equities process. We don't know anything about it, so we filed a FOIA request. They, of course, ignored the FOIA request, as they do. So we sued over it. We've gotten a little bit back. Most of it is too redacted to see anything. But expect more documents in 2015 on that, so that should be fun.
So another piece of litigation that we've been working on was our challenge to the national security letter power. This is a power that the statute has granted to the FBI, where they can go to a service provider and hand them a letter. The service provider is then supposed to identify the account information about one of its users and to never speak of the letter again. And the FBI has issued hundreds of thousands of these letters. There have actually been, I believe, 6 challenges to it, so there's not very much incentive for a service provider to bring forward that challenge. We believe these are unconstitutional, both because of the perpetual gag order that doesn't allow the service provider to issue a true and honest transparency report and say how many national security letters that they've received. And substantively, because it is requiring information to be given up about somebody without any court involvement, without the judiciary saying that this is okay and that it's not going to infringe on somebody's right to speak anonymously. So we brought this challenge a couple of years back, representing 2 service providers. We cannot name them because of the gag order. And nevertheless, we were able to get the court to agree that it was unconstitutional. So the federal district court out in San Francisco found that national security power was unconstitutional. It stayed its decision pending appeal. So we just had the appeal in October. I argued before the Ninth Circuit Court of Appeal that they should uphold the district court's decision, and now we're awaiting the result on that.
The Ninth Circuit's average time to decision is 6 months, right?
6 months after argument.
So April would be average, and we have no idea when it's coming down. The other cases that you guys are probably pretty interested in here are the cases where EFF is suing the NSA for their various warrantless wiretapping and other mass surveillance programs. The oldest and sort of most high profile and one of the most important from our perspective is a case called Joule. This is a class action that we brought on behalf of AT&T customers after a whistleblower named Mark Klein walked into our office with diagrams of the secret room at the AT&T facility in San Francisco where they have a fiber optic splitter that everything going across the AT&T network is copied, and that copy goes to the NSA. The Joule case was filed back in 2008 and is still ticking away. We've been up to the Ninth Circuit and back on that case. Our current judge is a very thoughtful man and takes forever to rule on anything. The most recent hearing there was on cross motions for summary judgment, very technical proceeding, but could have significant impact, and that was in December. We have no idea when he's going to rule on those cases. The other case that is in front of Judge White is First Unitarian Church et al. Versus NSA. This is a case where we represent 25 different membership organizations challenging the telephone metadata collection program, the 215 program, also called the BR FISA program. We represent a couple of churches, including the named plaintiff, the First Unitarian Church of Los Angeles, the Council for American Islamic Relations, a Jewish radical peace group, Human Rights Watch, Greenpeace, a medical marijuana group, a Second Amendment gun rights group, and some student groups, yay, gun rights, suing to get the 215 metadata collection program ruled unconstitutional because by definition what they're trying to do is figure out Americans' associations in that program. We also are co-counsel with ACLU representing a lovely man out of Idaho named Peter Smith and his wife, Mrs. Smith, I don't know her name, who are suing the NSA over the same program. He represented himself in Idaho District Court and did a great job, but lost there and asked for our help at the Ninth Circuit level. That case was argued in the fall as well. December 8th. And so that case was actually argued on expedited briefing schedule, so we may get a ruling from the Ninth Circuit in the next couple of months on that one.
So in addition to our litigation work, we do some other things. One of them I wanted to mention was our Encrypt the Web advocacy. So this is both a technology and an advocacy project. So one of the things we have the Encrypt the Web report. So we went through and looked at about 25 major websites and looked at what levels of encryption they were offering. Do they have SSL by default? Do they have HSTS, forward secrecy, these various things. And then if they did, we would give them this nice green check mark. So we published that a little over a year ago, and initially only a few companies had a lot of check marks, but pretty soon a lot of them were getting into it. They said, hey, we've turned this on, could you give us a check mark? And so over the last year, we've had a fairly astonishing increase in the number of these major service providers who are deploying encryption throughout their platform. One of the ones that I'm particularly pleased about was we gave a check mark for using Start TLS for email services. And at this point, most of the major webmail providers, Yahoo Mail, Gmail, Outlook, are using Start TLS, and this encrypts the communications as between the two services. So if somebody is using SSL to go to their webmail, Start TLS between the two companies and the SSL on the far end, then there's encryption along every step of the way. It's not end-to-end encryption, but it's along every step of the way, and that really helps protect against bulk surveillance that is trying to look at the wires.
Another encryption project that I've been working on recently is the Secure Messaging Scorecard. This is a project of EFF and ProPublica, a nonprofit news organization. And we look at messaging clients or messaging apps and rate them on seven different criteria, whether they use transport layer security, whether they do end-to-end encryption so that the provider can't read it, whether there's forward secrecy, whether their design is documented, whether their code is auditable, whether their code has been audited, and give check marks for various programs in each of those categories. It's been interesting to see how the companies have reacted to this report. Some of them have reacted quite well and actually have given us documentation and made public documentation, which hasn't been public before. Apple was great with this. Some of the other companies have not been so good, and you can see the results at eff.org/SMS for Secure Messaging Scorecard. I've also been working with the international team, as has Kurt, on our surveillance self-defense guide. This is a sort of how-to for activists, for journalists, for regular people who want to start using crypto. And it's awesome. It's targeted at Mac users and at Windows users and at Linux users, and mobile clients, both Android and iOS, are addressed there. And it begins where every surveillance self-defense guide should begin, but so many don't, with a guide on how to threat model. Right? Are you an activist in Syria where Google services are probably fine? We help you identify that. Or are you someone with work in the security research community with a very advanced threat model? Maybe you shouldn't be storing all of your docs in Google Cloud. We help you address all of those questions.
I just want to briefly mention a couple of our software projects. We have HTTPS Everywhere, which is a browser add-on that will help if there's a site that does not default SSL but allows for it, then HTTPS Everywhere will make that connection be secure transparently in the background, and we keep on adding more and more sites to it, so it's a nice handy tool to help protect you while you surf. There's also Privacy Badger. This is another browser add-on, and it is a tool that attempts to identify algorithmically tracking cookies and then block them if they are exhibiting the behavior of a tracking cookie. So I see we have a question there. If you want to just come up here and we'll hit the questions actually pretty...
Just a moment.
Yeah, just a minute. Anyone actually, if they have a question, just line up here and we'll start taking questions in just a moment. So Privacy Badger helps protect you against tracking cookies, and it's using a model different from the whitelist or blacklist model because of some of the difficulties that come from that, keeping those lists up to date, and rather trying to do a behavioral model. So check that out. And then upcoming technology project called Let's Encrypt, which is designed to make it super free and easy to get a certificate so that you can add HTTPS to your website without having some of the encumbrances that were previously a challenge. That is, we've published some information about that. You can go check that out at just Google for Let's Encrypt, and it should be rolling out in June.
Yeah, it'll be super cool. You'll be able to literally type sudo apt-get install Let's Encrypt, and you're in, I think it's 90 seconds or so, your Apache instance will be configured to do SSL, and you'll have a certificate that will be trusted by default in every browser for free, which is pretty awesome. When we're talking, I'll talk a little bit about patents. So neither Kurt nor I are patent lawyers. We do have patent lawyers on staff. So I don't know much about it, and if you ask me a question about patents, I'll probably say I don't know. But I do know that we have a patent busting project at EFF, and one of the patents that we're going after right now is a patent on podcasting. There's a company called Personal Audio that claims to have patented podcasting and is going around suing podcasters, or not suing, but threatening to sue and extorting money from them. So we filed what's called an inter partes review in the patent office, the filing fee for which is $25,000, which is the most expensive lawsuit we've ever filed. And we're waiting for a decision on that, and we think we made a very good case. We also have a stupid patent of the month that we list every month on our website. The most recent was not actually a patent, it was a patent application. Uber has patented...
Or applied to patent.
Applied to patent, supply and demand. So we hope that the patent office will recognize that you cannot patent supply and demand by adding the words on a computer afterwards, which is essentially what Uber did. All right, question?
Yeah, let's take it to your questions. So, let's see, how shall we do this? Well, you can just sort of come up here and...
line up at the podium, why not?
Come up to the podium, yeah.
This is your moment to shine.
This is actually a question asked by somebody on the streams. They are curious, in your opinion, what is the hardest case that the EFF has ever won?
Hardest case that we've ever won? Well, that's a good question.
The NSL case at the district court level.
Yeah, I think that's a good contender. I mean, at least we won at the district court level, and this is the one I had just mentioned about national security letter powers. And as I said, there were about 6 cases that have challenged it, and it is a tough thing to challenge, because when the FBI goes to the court and says if we lose this power, there will be great national security at risk, it's asking a lot for the court to agree. And even though I think that the actual First Amendment law on whether you can indefinitely gag somebody without a judge is pretty good that you can't, nevertheless, it has historically been a struggle for those who have challenged it, and we're very proud to have won that at least at the district level, and we need to defend it now.
And I'll give a second answer to that as well. We represented Andrew Arnheimer Weave on appeal in his hacking case. It wasn't a particularly hard case per se, but I think it's an important example of, even people who are pretty terrible deserve a defense, right? Weave may have done some bad things in his life, and he might be the first to admit this, but what he was convicted for was not a crime. So even though Weave is Weave, we represented him, and I think that's as it should be.
So I have a quick question and a slightly more elaborate one. The quick question is anything being done about something like HTTPS everywhere for mobile? Because I noticed that I don't think there's any way to do that on mobile, which is, I know where an increasing part of my browsing happens during commuting and elsewhere.
Yeah, Firefox on Android, I think we have, I think there's an HTTPS everywhere for Firefox Android. Okay. Apple doesn't allow us to do that.
And anything on Chrome?
It's on Chrome in the browser version, but I don't think for the mobile yet.
I don't know if it is.
All the code is up on GitHub, so GitHub's the account is EFF.org, and so you can see what code is available there.
All right, and the slightly more elaborate one is that there was a talk the other day yesterday about a messaging app that a team was developing that originally started out as a secure messaging app, and then due to a demographic shift and some implementation issues, they also were downplaying the importance of encrypting metadata of who is sending and receiving messages to and from whom. And I was curious if you could speak to the importance of that, or why that may or may not be important.
Well, metadata is something that is important, and it depends, though, a lot on what your threat model is. So, for example, for PGP is a very good encryption if one, you're pretty good at using PGP, and that can be a challenge for some. And second, if what you really want to protect is the content of the message. So the fact that you emailed somebody and when you emailed them would not be concealed by that. If you want something that is also going to conceal your metadata so that someone can't do a graph, can't do the kinds of analysis that come from metadata, that is a harder challenge in secure applications, but I think Pond is trying to solve
Pond
that.
is about the only product that will solve that. But Pond is, please don't use Pond yet. It's not ready. Yeah.
So
unless you're the Grok, and then go for it.
What you need will depend on your threat model and your ability to handle some forms of tools that are perhaps not as user friendly and not as easy to use, but provide a higher level of security.
I suppose a slight revision of the question would be, in the context of the general using, public using message applications, specifically in the context of things like NSA mapping of metadata for graphing out relationships.
I mean,
How would you rate the importance of it?
it's very important, but yeah, okay, I'll repeat the question. How, in terms of NSA mapping out relationships, that sort of thing that we know is going on, how important is it that metadata be masked or encrypted? And I think it's very important. It's very difficult, and essentially no one is doing it right now.
Yeah, and certainly the NSA, I mean, in public statements they will say things like, yeah, it's just metadata, don't worry about it. And of course, as probably most people in this room understand, there's a lot that can be gleaned from metadata, and when this is a challenge that we have, is that metadata can be used to find out some very personal things about someone, especially if you are sitting on the wire and you're able to observe a large number of communications over time and put analysis on it.
Right. I mean, even things like Wicker and TextSecure that do some metadata masking and some encryption of metadata, the pattern analysis is still available.
So back on Weave for a second. So in our amicus brief, we spent a lot of time emphasizing consumer protective research. Mm-hmm. And when the Third Circuit threw out his case because of the minor technical issue of fundamental constitutional law, we lost the opportunity to get that done in the Third Circuit.
Yep.
Are there any cases coming up where that would be a helpful argument that EFF could be making or that other groups could be making?
I'm not aware of any in the pipeline.
Okay. You have like a bat signal thing like Popat does to say,
Yeah.
hey, we need some group of idiots with way too much free time to do this.
Well, we try not to manufacture cases, especially criminal law cases, because that can be really kind of tough on the person who's volunteering. But when we actually have a lot of pretty good connections with the National Association of Criminal Defense Lawyers, who are a lot of good people there who don't have quite the same experience with technology issues, and so when cases having to do with computer crime or technology issues come up, they often will reach out to us, and that gives us an opportunity to find cases to make good law. I mean, other than good law about jurisdiction and venue.
Yeah, and we're always looking for them, so if you happen to hear about one, email us, info@eff.org.
So the problem of stacking of charges that comes up in cases like Weave and Aaron Schwartz, do you see any improvement in that area, or is that still just not getting any better and it's unlikely to improve because it's such a good tool for them?
Well, it is something that under the current set of laws, they've certainly enjoyed to do. And just to explain to everybody what we're talking about, under the current Computer Fraud and Abuse Act, there's a number of things which are misdemeanors. You might say, well, gee, that makes sense. Sometimes somebody might make a mistake, but you don't want to put them away for many years. It's nice to have that balance out there. But under the current CFAA, it says that if you do it in conjunction with another crime, then it bumps up to a felony. Well, it turns out that every state has a state version of the CFAA, state law anti-hacking statute, and so always you can find another law that you're violating, then stack it together and come up with a felony. So it turns out that in practice, they've been constantly doing this sort of stacking thing. So an interesting part of the Obama administration's proposal they just came out with on Wednesday is they put in a nod to that stacking issue there, and they said in one particular situation that it had to be stacked with something that wasn't solely the same crime at the state level. And they used that word solely, which was kind of interesting because it makes you, at least brings up the question, well, what if it's like almost the same, but there's like one other little difference, and it's not solely. And that is something that has been raised, and we'll see if anything gets done with that as this law moves forward. What we would like to see is that if you're going to put two crimes, you're going to do hacking in furtherance of another crime, that other crime has to be not hacking. So you're doing it in furtherance of bank fraud. Okay, you can charge those things separately, but if you're doing it in furthering of also doing the same thing, then that bootstrapping shouldn't be allowed, and we should have misdemeanors so that some people who might get caught up in the law have a chance to perhaps learn from their mistakes without having to spend years in jail to do it.
Kurt and I actually were at the DOJ yesterday in a meeting about this proposal, and we told them exactly that position, and they smiled and nodded.
Okay, so I wanted to, first of all, throw in one comment about the metadata discussion, and then I'll have a different question.
Sure.
So there's this wonderful quote by Michael Hayden, who was the director of NSA and then the CIA, that said, well, we kill people based on metadata. There's actually, this is really true. There are drone strikes that are done, that are called signature strikes, where it's like, this person fits a pattern of looking like he might be a bad guy, so we'll blow him up, and anybody around him and all that. Mm-hmm. So whenever I hear somebody say, oh, metadata doesn't matter, my first thought is unless you're one of the people who gets killed for it, in which case it sucks. So that's the first thing. The other thing is I wanted to know what your thoughts are on warrant canaries. I've seen a lot of people trying to come up with these sort of warrant canary ideas, and they always strike me as being the equivalent of what happens when a non-technical person tries to imagine a technical solution, except applied to law. But I'd like to hear your thoughts.
No, I appreciate the question. So for those who aren't familiar, the notion of a warrant canary is that you have a sign to the effect of we have not received any national security letters. And having not received one, you're not under any obligation to, you're not under gag order yet. And then when you do receive one, well, you're under the gag order. And then it poses this sort of interesting constitutional question: can the government force you to lie? Can they compel you to speak and say that you have still received zero when that's not true? Or can you just remove it and say nothing, and then people will draw whatever conclusions that they draw from that? Can you be honest about it, which is challenging the underlying thing? So I think there's something interesting about this. That there is some pretty interesting case law about compelled speech. It does happen from time to time. The government can compel you to speak, but the examples are usually in the commercial context, like the warnings on cigarette packs. And this is a message that the cigarette companies don't want to be on there, but because it's commercial speech and because there's a great state interest in giving people health warnings, they have been compelled to speech. But in a lot of those cases, what the courts are looking at, well, is the information true? And if you could say that the warning that they wanted you to put on your product was not true, then you would be able to not be compelled to fight the compelled speech. So it's interesting. It's untested. No one has actually had a court rule about a warrant canary in particular. If there were to be a case that we're going to challenge the constitutionality, to say that you can't be compelled to lie, and to allow this, I would like that case. Please call us. And also, we would like that case to be one which was done in the best possible manner. That is to say, getting out ahead of it, going to the court before the time when you had to either remove or not remove your canary, getting a declaratory judgment. So this is when a court declares what the law is before you violate it, and brief that out, and hopefully we can do something on that. To the point from the question about some of them seem like some convoluted setups. And one thing that I would say, like on the whole, if you're going to go to the court and be litigating out whether you can have compelled speech and whether you can give an honest transparency report and so on, if the system setup looks like it's really, really cute and that you're trying to find hack the law essentially, the judges are not keen on that. And if it looks like it's too cute by half, they are willing to say, you know what you're really trying to do here is convey information that you're not supposed to be conveying, and I can see through your cuteness to what you're really trying to do. It's harder to hack the law than it is to hack a machine.
So the take home here is that if you're a site operator and you want to do a warrant canary, do it something like once every 6 months and put it on a few-month delay, because as much as Kurt and I like staying up all night to write emergency briefs, which we do, we like, that's fun, we don't like to do it very often, so please let us have time to write the brief.
Hello guys, thanks for answering all these questions. They've been really informative. I want to say I fully support you guys and the foundation. My question is a little bit more low-key than a lot of these top-notch questions, which I appreciate. In regards to drone video recording, what is your position on privacy and distribution of that video, and can the government access the video without permission?
Are you talking personal drones
Yes.
like in the U.S.?
I mean, 2015 is the year of the drone, so, I mean, we have next-door neighbors, we have people in the parks, businesses.
Our colleague Jen Lynch.
I got one for Christmas.
That's a great
sweet.
question.
So the expert in our office on drones is our colleague Jennifer Lynch. She's been looking at drone issues for quite a while. So, I mean, I'm not all that expert on that. Nate, do you?
So I'll give a classic lawyer answer and just illustrate the tension here, right? There are ways that you can use a drone that are clearly invasive of others' privacy, and there are ways that you can use a drone that are clearly protected by the First Amendment. Like if I'm the Associated Press and I want to, film a wildfire using a drone, that's arguably First Amendment protected activity. So our position right now, essentially, is that regulating the private use of drones within the United States is very difficult. Most of the proposals that we've seen have been mixed, but we right now are focusing more on regulating, or trying to figure out proposals on how to regulate law enforcement use of drones, because that's easier, right? To regulate law enforcement use of drones, there is a best case scenario, which is a law saying you got to get a warrant before you use a drone to do photography or surveillance. Very few states have such laws, and we're working hard in the states that don't. Compare that to a traffic camera is the question. Traffic cameras are different in a couple of ways. They, generally speaking, don't actually send live video. Sometimes they do. But they're conspicuous, right? You know where they are, they can be mapped. EPIC, the Electronic Privacy Information Center, which is based here in DC, did a nice project a bunch of years ago mapping all of the traffic cameras in Washington, D.C. In D.C. they all send live? That's good to know. Oh, that's fun. But you know where they are, right? And they're not in your backyard. That's the difference.
So by this point, I'm sure a lot of people have noticed that residential ISPs have a nasty habit of injecting things into HTTP streams. So you've got ads, or there was an ISP that injected like a notification that their email servers were down into their pages. Is that legal? If so, why? And if so, are you guys seeing any avenues or making any progress in making that not legal besides, just encrypting everything?
Well, I mean, so yeah, you should probably. I mean, there are some self-help that one can do in that, like using a VPN and going to encrypted websites. And so part of what we're trying to do is make everybody always be going to encrypted websites, so it's harder for someone to do that kind of attack. Whether it's legal, I mean, I would imagine if they had quality in-house counsel, they wrote something in their terms of service which said that by using their service you agreed for them to be able to do that. But I mean, sometimes there have been instances in when things have gotten injected without anyone's permission, which maybe you should talk about the Verizon thing a little bit.
Sure. So it turns out that Verizon Wireless, not their landline ISP, but the wireless ISP, is injecting a unique tracking identifier in all HTTP requests called UIDH. You can opt out of the marketing term that they have for this program called Precision ID, but that only opts you out of Verizon selling more information about you and doesn't opt you out of the actual injection of the unique identifier. I think this is pretty clearly illegal under both the FCC Act and the FTC Act, the Federal Trade Commission. So this is an unfair and deceptive trade practice, as well as Verizon spewing CPNI, consumer
Proprietary network information.
Proprietary network information to anyone or to everyone that person visits. So the answer is yes, it's sometimes illegal. Yes, it's probably sometimes legal if they've drafted their terms in a nefarious manner. This is why we need net neutrality, frankly.
So follow-up question on that. If ISPs are doing this, does that, do you think, interfere with their common carrier protections?
I actually don't know the answer to that.
Okay.
So, I mean, that's getting into where the FCC Act is, and for some of them, which are FCC regulated things, they are subject to that. It's actually with like Verizon Wireless, it is very clear that they're an FCC subjected entity because they bought into a certain amount of wavelength, and they're doing that. For a broadband provider, it's a little bit different, but some of them are covered entities because they're also like cable companies. But anyway, the short answer is I'm
so
sure.
Right. The ISP's argument would be that they're not a common carrier, and this is why we need Title II reclassification.
Okay, thanks.
All right, I think last question.
All right, it might be a long question, I apologize. So one thing that I haven't heard a lot about lately that I would love to hear more about is this concept of the right to be forgotten, as we've seen somewhat in Europe. And so with a predicate of a few things, such as large companies like Google maintaining copies of your data, potentially in backups that would be technically difficult to remove data from reliably, and other scenarios such as the reference implementation for PGP key servers, SKS, deliberately keeping not necessarily data so much as metadata in terms of a large social graph of people who have met each other and signed each other's keys. What do you think, and of course the problems that we've had with personally issued or privately issued takedown notices, combined with the public goods that are often involved in having data about other people out there, what do you think is an appropriate domestic policy direction or recommendation or balance of these goods in terms of your right to not have data about you or data that you have moral rights in out on the internet for everyone to see?
All right. Well, there's a lot of things wrapped up in that question. Let me, we only have, I think, 2 minutes left, so I'll see what I can do. So on the right to be forgotten, and for those who are unfamiliar, this is a notion that's coming out of Europe that true facts about you can be taken down because they're embarrassing to you, and you should be able to have that aspect of your history forgotten. This runs up against some of the free speech notions that we have in the United States, which is that truthful speech is protected and the government can't compel you to remove something, a truthful statement. My introduction to the right to be forgotten was a while back, and it was somebody wanted a Wikipedia page taken down that was about a murder that they had committed, and they had served their time, and they thought, well, people shouldn't be able to know about how I killed somebody. And I disagree. I thought, that it's very important. I understand the privacy interests, and that oftentimes people will have their information put up, and maybe they didn't fully realize how long it would last or how public the audience would be, and so thus there's information that they would prefer to not be on the web. But that's a challenge when it comes into conflict with somebody who wants to express that information, and if it's truthful. So that's sort of the tensions, at least, behind that. Yeah.
I mean, so you mentioned moral rights. That's actually not a concept in U.S. law. It is a concept in European law, and there's always going to be a tension between free speech or free expression and privacy. Those concepts are at tension, and in the U.S. we've resolved that tension differently than the Europeans have. Under the way that U.S. constitutional law works, we will never have a right to be forgotten in the U.S. It's just, I don't think it's consistent with the way that we've decided our norms. So it's going to be interesting. There's going to be a European internet and a U.S. internet, and they're going to be different.
Okay, well, we are out of time, so thank you so much for coming, and we appreciate all of your support. If you're not a member, come on down to our booth and become a member. We love it.
And if you want to continue this discussion, we're going to go to the lobby bar